Good to be among friends. Good afternoon, and thank you for the opportunity to speak with you. I'm here today to discuss felony disenfranchisement in Tennessee. By continuing to deny citizens the right to vote based on criminal convictions, our government, both the United States and the Tennessee government, is endorsing a system that expects these citizens to return to our communities and to contribute, but denies them their participation in our democracy. Not only is disenfranchising millions of American citizens, and in fact hundreds of thousands in Tennessee, undemocratic, but it is counterproductive to the rehabilitation and reintegration of those released from prison. Before I begin my formal presentation, I also want to take a moment to underscore the importance of pursuing and ensuring equal treatment and protection for all Tennesseans, regardless of their race, their religion, national origin, sexual orientation, gender identity, and economic or social status. Our state has a rich legacy in civil rights and civil liberties activism, from the sanitation strikes in Memphis, to the training workshops at Highlander Educational Center, to the lunch counter sit-ins in Nashville. And our challenges are many, and our work continues, but I do have to say I remain confident that we will succeed in creating a Tennessee where justice and fairness will prevail. And thank you for setting the scene and allowing these conversations to take place. So voter disenfranchisement, or to be more positive, voter restoration. Voting is a fundamental right and a cornerstone of our democracy. The United States has said that the right to vote is preservative of all rights, and yet millions of Americans have had their right to vote revoked because of a criminal conviction. Upon release from incarceration, these citizens work, they pay taxes, they live in our communities, they raise their families, and yet they are without a voice. In 2010, an estimated 5.85 million citizens could not vote as a result of a criminal conviction. And these folks are they're in jail, they're in prison, they're still on probation or parole, or they owe fines and fees, and so their voting rights have not yet been restored. But of that 5 million plus, nearly 4.4 million, almost 75% of those have been released from prison, and they're living and working in our communities, but they have not had their voting rights restored and can't yet get them restored. Of the total disenfranchised population, about 45%, which is about 2.6 million people, have completed their sentences but reside in one of the 12 states, which includes Tennessee, that disenfranchise people post-sentence, okay? So after they've left prison and after they've completed probation and parole. The Sentencing Project out of Washington, D.C., which is a fabulous resource, also estimates that in 2010, 341,815 Tennesseans, which is 7% of the state's voting age population, were denied the right to vote because of their criminal record. Approximately 72% of those Tennesseans, which is about 247,000 plus individuals who were disenfranchised, were no longer incarcerated and had actually completed their parole and probation. Worse still, many felony disenfranchisement laws, like the recent photo ID laws that we see popping up all over the country, those laws are rooted in the Jim Crow era and were intended to bar minorities from voting. The impact of these laws continue today. Nationwide, 1 in 13 African Americans of voting age have lost the right to vote, and that's nearly 7.5% of voting age blacks compared to less than 2% of non-blacks who cannot vote. In Tennessee, 19% of African Americans were disenfranchised. Now that number includes folks who are also still in prison and can't vote, as well as those who have completed their sentence and are either permanently disenfranchised forever or have not yet been able to get their voting rights back. Of the estimated 247,808 former felons, 105,817, which is approximately 43%, are African Americans. Over the last few decades, the number of disenfranchised citizens has been increasing because of an incarceration boom fueled by mandatory minimum sentences, prison privatization, and the war on drugs. In turn, this has impacted the families of those who are disenfranchised and the communities in which they reside by reducing their collective political voice. There's been a lot of public attention nationwide. Recently, Attorney General Holder talked about the importance of being able to see disenfranchised folks, those who have had convictions but have now been released from prison, be able to have their rights restored. And most recently, I think this weekend, Senator Ron Paul was in Memphis, and while he didn't say it publicly as he was speaking to one of the political parties, he did speak to Memphis pastors and raise the concern he has about the huge number of disenfranchised African Americans in the community and across the country. There is no question that Tennessee has one of the most punitive and complicated felony disenfranchisement statutes in the country. Tennessee is actually just one of 10 states that permanently disenfranchise some or all of its citizens for being convicted of certain crimes, meaning they can never ever get their voting rights back. Tennessee maintains a growing list of felonies for which permanent disenfranchisement is the penalty, including nonviolent crimes such as voter fraud, bribery, and interference with government operations. For those who are eligible for restoration, Tennessee, along with 20 other states, require that the sentence and probation or parole be completed. Tennessee law also requires that all fines, fees, and restitution be paid in full. And then, Tennessee, unlike any other state, requires that the former felon be current on their court-ordered support payments, court-ordered child support payments. Now, history is important, and I think we need to know that prior to 2006, the type of offense and the date of conviction actually guided one's eligibility and the process required to restore one's right to access the ballot box. In addition, every individual had to be involved in a judicial proceeding, which was required in order for the individual to have their voting rights restored. During the 104th General Assembly, ACLU, along with the Tennessee Bar Association, the state NAACP, championed legislation that would streamline and standardize the complex restoration procedures. That new law, which passed, represented a step forward, and also eliminated the required signed court order, replacing it with a required signed certificate of restoration by the Board of Parole and Probation. Unfortunately, and this is, again, important to realize what was happening in 2006 and is where we are today. Unfortunately, at the 9th hour, legislators added 2 financial preconditions before individuals with felony convictions could get their voting rights restored. Former felons had to pay all restitution to the victim or victims of the offense ordered by the court as part of the sentence, and they had to be current in court-ordered child support obligations. Now, no one is denying that those fees and that responsibility should be removed from the individual with the felony conviction, but one has to question whether or not adding that burden to individuals with felony convictions will ever then result in them being able to access the ballot box. While a number of states require individuals to pay fines, fees, and restitution before they can register to vote, again, Tennessee is the only state in the country to require child support payments, clearly an impossible financial obstacle to overcome for most individuals coming out of prison. In addition, there is no link between child support payments, good parenting, and the right to vote. In fact, as the legislation was being debated on the floor, Representative Tommy Brown, who's no longer in the legislature but was a social work professor at University of Tennessee, pointed out that many divorced parents are not current in their child support, and actually suggested that perhaps the legislature should consider next requiring that those parents be current in their child support before they could cast their vote. And that was just to make the point that this particular provision was going to target a certain community of folks, typically those in the minority community, and without question those who, if they were not poor when they entered the facility, would certainly be poor when they got out and have a lot of difficulty just accessing housing and employment. ACLU filed a lawsuit, Johnson v. Bredesen, challenging the child support financial requirement and the restitution payments as a precursor to having one's voting rights restored. And in a very troubling 2-1 decision, the Sixth Circuit Court of Appeals upheld the financial requirement, choosing to ignore the seriousness of Tennessee's effort to disenfranchise its citizens. ACLU had argued that the law violated the 14th Amendment Equal Protection Clause and the 24th Amendment ban on poll tax. But in their 2-1 decision, the Sixth Circuit refused to accept that the restitution or child support requirements were financial barriers to voting, like what had been known as the poll tax, the unconstitutional poll tax. The court also dismissed the notion that the law suffered constitutional flaw because of its disparate treatment of individuals based on their wealth. Instead, the court held that the state had a rational interest in collecting restitution payments and child support payments, which justified, they believe, the denial of voter restoration. So the court basically, in this case, legitimized a pay-to-vote scheme in Tennessee. Those with the financial resources can pay to have their rights restored. If a citizen, as many former convicts are unable to find a job to repay their financial obligations after exiting the correction system, the court assumes that they are not worthy of participating in the political process. And we know then that challenges the process of reintegration into our communities, and then also challenges public safety issues that all of us are concerned about. Dissenting in the Johnson case, and the one dissent is sometimes always where you find your solace, Judge Karen Moore focused on the law's unequal treatment of disenfranchised citizens based on their ability to pay, and she said, quote, "It is indisputable that the plaintiffs are now unable to access the ballot box simply because they are too poor to pay." Judge Moore called the state's attempt to collect child support payments that an individual cannot make by linking those payments to the right to vote as, quote, "nothing more than an attempt to exercise unbridled power over a clearly powerless group, which is not a legitimate state interest." It's also important to note that the current law also requires that the former felon, again, who has completed their sentence, parole, probation, and has paid back all of their fees, including child support, that individual must then confront a series of burdensome steps in order to register. First, they have to secure the certificate of restoration and have it signed, first by their parole officer, and if they can't find that officer, and we know there's a lot of turnover in those positions, by someone else who has a history that this individual had completed parole and probation. Then they have to have the certificate signed by the criminal or circuit court clerk, certifying that all court-ordered restitution has been paid in full. And then they must bring the certificate to the local election commission, who sends it to the state election commission office to certify that all court-ordered child support payments are current and that the certificate of restoration has been completed correctly. And it's only then that the state election commission sends a notice to the local election commission certifying that the certificate has been approved or denied. It is the responsibility of the local election commission to notify the individual that their certificate has been approved or denied. And it is only then, when learning that their certificate was approved, that the individual can go then back to the local election commission to complete a voter's restoration form. Very, very tiring, complicated process. So suffice it to say, this process takes time, it takes talent, and most importantly, it takes tenacity. In our state, we have across the state some wonderful advocates who are willing to work with former felons to help them restore their voting rights. But it is a process that needs to be made simpler and with far fewer steps. The goal should be expanding access to the ballot box, not restricting who has access. So there's no question that we have a lot to fix. And we would recommend several actions that the state could take, including the Tennessee General Assembly, to ensure access to the ballot box for disenfranchised former felons. One would be providing Know Your Rights information and workshops about the voter restoration process for individuals preparing to leave prison as part of the reintegration into the community. Two would be removing financial obligations that are not required prior to being able to register to vote. And 3, which we of course think is the most important, receiving, and the best recommendation, receiving automatic restoration of voting rights upon release from prison. As the United States Supreme Court has said, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Our rights, even the most basic, are illusory if the right to vote is undermined. We invite you to join with us to restore the most precious of civil rights that have been denied far too long to hundreds of thousands of Tennesseans. Thank you.
Do you have any idea how many people have actually gone through this recertification process and gotten their vote back?
So and these stats are all from the Sentencing Commission, and of the 247,000, I think it's about 2%. I don't want you to write that down until I get that number for you, but it's very, very small. We did a survey, and it's old now, it's about 6 years old, where we surveyed all 95 election county commissions, asking them how well they understood the new law, and it was sort of shocking how well they did not understand the new law. So I think the problem comes from both ends. It comes from the individual who just has trouble getting through the process because he or she doesn't understand it. They have other concerns, just getting that house and food and job. And then it comes from the need from the local election commissions to be better educated about how they can facilitate the process.
Who educates?
Hmm?
Who does the education?
Good question. And I think that's certainly a really important thing to ask the state election commission to take on.
One other thing I wanted to ask Hedy was, as you're looking at some legislation that's coming up next year to get some of these people restored, also look at the list of purge voters, sort of add those on there. I think that if a person is purged because of inactivity, that shouldn't be a disqualified. I think persons that registered to vote ought to be vote permanent. Should never be taken off unless it's a crime.
Well, the people who are purged typically are purged because they either haven't voted, correct?
Inactivity.
Yeah.
If you hadn't voted in the last 2 presidential elections, I've used that as it's used 2 federal elections, then you're automatically purged. And
yeah, problematic, especially when people don't realize they're going to be purged. The other thing to know is, just to be proactive, individuals who are awaiting trial, so pre-trial detainees, they have the right to vote if they've registered. And there's some very creative work people have done in terms of going to jails, that's where the pre-trial detainees are, and making sure they know that they need to register. And actually, in larger jails, bringing in they can vote absentee, but that's hard, bringing in a machine. And, some would challenge that, but I think, again, if we're looking to what our goal is, and is it to recognize that folks typically, certainly nonviolent offenders, are not going to be staying in prison. We don't want them in prison for any number of reasons besides the unfairness of it, and the cost, but they're going to return, and voting is a way to express your opinion and really make that understood as we want to hear people's opinions.
I would like to say, not as a commissioner, but as a person, and I've got a microphone in front of me, so I get to do it. Tennessee is a better place because Hedy Weinberg has been on the case for as long as she has.